Everybody. Mr. Registrar, could you please call the case?
Good afternoon, Your Honours. This is case number IT 0366A, the prosecutor versus Fatmir Limaj et al.
Thank you, Mr. Registrar. Mr. Bala, can you clearly hear and understand the translation?
Yes, I can understand you.
Thank you, Mr. Bala. I would now ask for the appearances of the parties. First, the defense of Mr. Limaj.
Good afternoon, Mr. President, Your Honours. Karim Khan, in the absence of lead counsel Michael Mansfield, for the respondent, Fatmir Limaj.
Thank you. The defense of Mr. Bala.
Good afternoon, Your Honor. Gregor Guy Smith appearing on behalf of Mr. Bala with the assistance of Carolyn Bausman, Bart Williamson, and Genti Zuberi.
Thank you. And now for Mr. Musliu.
Good afternoon, Your Honours. Stephen Poles on behalf of Isak Musliu. Lead counsel, Mr. Michael Topolsky, has asked me to convey his apologies to the Appeals Chamber this afternoon for being unable to attend at this hearing.
Thank you. Now for the prosecution.
Good afternoon, Your Honours. Helen Brady appearing on behalf of the prosecution, together with Sheila McCall, Christina Carey, Stefan Wirth, and our case manager, Mr. Sebastian van Hooydonk.
Thank you. As the registrar announced, the case on our agenda today is prosecutor versus Fatmir Limaj, Haradin Bala, and Isak Musliu. In accordance with the order rescheduling the hearing issued on 18 September 2007, the Appeals Chamber will deliver its judgment today. Following the practice of the International Tribunal, I will not read out the text of the judgment except for the disposition. Instead, I will summarize the issues on appeal and the findings of the Appeals Chamber. The summary is not part of the written judgment, which is the only authoritative account of the Appeal Chamber's rulings and reasons. Copies of the written judgment will be made available to the parties at the conclusion of this hearing. This case concerns the events that occurred in a prison camp in the village of Lapušnik and in the nearby Berija Mountains between May and July 1998. The three accused were indicted for crimes committed in this period against Serbian civilians and Kosovo Albanian civilians who were perceived to be Serbian collaborators. The indictment alleged that these civilians were detained in the Lapušnik prison camp where they were subjected to inhuman conditions and routine assaults, beatings, and torture. Some detainees were alleged to have been murdered in the course of the detention, while others were allegedly executed in the nearby Berija Mountains or on about the 26th of July 1998. On the 30th November 2005, the trial chamber found Haradin Bala guilty of acts of torture, cruel treatment, and murder, all violations of the laws or customs of war under Article 3 of the statute. Haradin Bala was sentenced to a single sentence of 13 years imprisonment. Fatmir Limaj and Isak Musliu were acquitted of all charges against them. Haradin Bala and the prosecution appealed the trial judgment on 30 December 2005. The parties made oral submissions before the Appeals Chamber in the appeal hearing on 5 and 6 June 2007. I will now address the grounds of appeal in turn, beginning with Mr. Bala, who brings 5 grounds of appeal after having previously withdrawn 4 grounds. I will then address the prosecution appeal against all 3 accused, beginning with Haradin Bala and followed by the appeals against Limaj and Musliu. The prosecution's common ground of appeal against all 3 accused in relation to the existence of a systemic joint criminal enterprise will be addressed in the context of the prosecution's appeal against Bala. Finally, at the end of the hearing, we read out the disposition of the judgment. I now turn to Haradin Bala's appeal. In his first ground of appeal, Haradin Bala argues that the trial chamber erred in law and fact in finding beyond reasonable doubt that he was the guard Shala who committed the crimes for which he was convicted. Haradin Bala submits that the trial chamber did not apply or misapplied the principle of in dubio pro reo when it failed to give any weight to the failure of 3 eyewitnesses to identify him as the guard known as Shala from a photo spread. The appeal chamber considers that the trial chamber reasonably assessed all of the evidence, including the failure of the 3 eyewitnesses to identify Bala, in concluding beyond a reasonable doubt that Haradin Bala was the guard known as Shala. Consequently, the appeal chamber finds that the trial chamber did not misapply the principle of in dubio pro reo. Haradin Bala further submits that the trial chamber's failure to attach any weight to the mistaken identifications reversed the burden of proof. The appeal chamber finds, however, that the trial chamber did not reverse the burden of proof, as it was satisfied that the cumulative effect of the other evidence on the identification of Haradin Bala as the guard Shala established this fact beyond reasonable doubt. Lastly, Haradin Bala argues that the trial chamber erroneously relied on in-court identification of him as the guard known as Shala. The appeals chamber finds that the trial chamber did err in law when it ascribed even slight probative weight to the in-court identifications. However, the appeal chamber finds that the error does not invalidate the decision. The appeal chamber recalls that the trial chamber reasonably found Ivan Bakrash's identification evidence to be particularly convincing. Therefore, having found that the trial chamber reasonably attached a significant probative weight to the testimony of Ivan Bakrash and only slight probative weight to the courtroom identification evidence, the appeal chamber declines to find that the trial chamber would have reached a different conclusion had it not taken account of the courtroom identification evidence. As a result, Haradin Bala's first ground of appeal is rejected. In his second ground of appeal, Haradin Bala submits that the trial chamber erred in fact in finding that he participated in 9 murders in the Berisha Mountains on 25 or 26 July 98 because he was incapable of walking the prisoners into the Berisha Mountains. Alternatively, Haradin Bala argues that the trial chamber erred in law by shifting the burden of proof and requiring him to demonstrate that he was physically incapable of engaging in the 9 murders. The appeal chamber is satisfied that the trial chamber reasonably held that Haradin Bala was physically capable of walking the prisoners into the Berisha Mountains because he had already shown that his medical condition did not prevent him from partaking in certain physical duties in service to the Kosovo Liberation Army. As to Haradin Bala's alternative submission, the appeal chamber is not satisfied that the trial chamber improperly shifted the burden of proof and required him to demonstrate that he was physically incapable of engaging in the 9 murders. The appeal chamber notes that the trial chamber was reasonably satisfied that the prosecution had fulfilled its burden of negating any reasonable doubt that he was physically capable of engaging in these acts. For similar reasons, the appeal chamber also rejects Bala's claim under his fourth ground of appeal that the trial chamber shifted the burden of proof in relation to his alleged physical incapability of engaging in the cruel treatment of witness L12. With respect to his alleged personal participation in the murders, the appeal chamber finds that the trial chamber carefully weighed the evidence when it held that Haradin Bala was present and directly involved in the shooting. Although the ballistic evidence neither established nor precluded the participation of a third KLA soldier in the murders, there was no evidence to suggest that Bala left the execution site prior to the murders, and thus the trial chamber's failure to discuss this issue does not constitute an error of fact. Furthermore, the appeal chamber notes that there was evidence demonstrating that Shala was seen with an automatic weapon, which was the type of weapon the ballistics evidence determined was used in the murders. As a result, Haradin Bala's second and fourth ground of appeal are rejected.